very warm good evening, everyone. Before we proceed and deep dive into the topic, I take this opportunity to felicitate our esteemed speakers. May I request Mr. Himanshu Arora, CGM, to kindly present Justice Mehta with the bouquet. May I now request Mr. Uday Aditya Banerjee, Advocate on Record, to kindly present a bouquet to Mr. Paramjit Singh Patwalia, Senior Advocate. May I request Mr. Nipun Saxena, Advocate, to kindly present a bouquet to Mr. Nalan Kohli, Senior Advocate. Thank you so much. Ladies and gentlemen, we have gathered here today for a conversation that many in the legal profession avoid in public, but one we urgently need to have within: ethics in a transforming legal profession. The transformation is undeniable. Social media has altered the grammar of professional conduct. Visibility is increasingly being mistaken for credibility. Legal commentary is compressed into reels and sound bites. Court proceedings are selectively reported. Judgments prematurely interpreted, and courtroom exchanges are sometimes curated for public consumption rather than institutional integrity. And while, as part of a two-day conference, we also have a specially curated fireside chat on the topic, Justice in the Age of Social Media, Ethics, Expression, and Institutional Dignity, this session focuses more on the ethics of the professionals in the profession. This is not a debate about technology versus tradition, but a deeper discourse on whether ethical norms are shaping the transformation of the profession, or is the transformation quietly reshaping our ethical boundaries. The issues are not abstract. They go to the core of public confidence in the justice delivery system. Today, the challenges to ethics are subtle but serious. Visibility often competes with credibility. Speed replaces deliberation. In such a climate, ethical boundaries are not always breached openly, but gradually diluted, normalized, and justified. And it's time that the profession must pause and introspect. If ethics weakens, the consequences are institutional. Public confidence erodes, judicial authority is questioned, and the profession risks becoming transactional rather than transformative. With this, may I invite our very first speaker for the session, Mr. Nalan Kohli, Senior Advocate, whose perspective from the bar is indispensable in understanding how evolving professional conduct directly impacts judicial process, decorum, and institutional authority. So,
I live with it.
thank you so much.
Thank you very much. Our Honorable Supreme Court Judge, Justice Sandeep Mehta, sir. My elder in the profession, Patwalia, sir. Several colleagues, I see Naveen Bhai, see others here, and I extend my warm greetings to them, friends, colleagues, and I see some students. We were at an event a few months ago where the Honorable Chief Justice of India, Justice Surya Kant, he said that courage is what you do when everyone is watching. Integrity is what you do when no one is watching. Now the question comes on a very relevant topic, and of course it's an onerous topic in a sense, because when we talk of ethics or ethical standards, we all are entitled to find our own moral compass. We look at examples, we learn from each other, but the question is, what is that moral compass on which we build everything? Ours is a noble profession. In fact, medicine and law is a more noble profession. And perhaps because, to a large extent, we earn from people's pain and distress. To a large extent, it's not always true, because there are positive parts to law also, bringing together the positivity. But essentially, people, as I joke and tell my colleagues, You don't go to a doctor saying, I'm in a great mood, I want an injection today. Likewise, you don't go to a lawyer and say, Bada badhiya mood hai, case kar lijiye. Life is not like that. So and therefore it's a responsibility. So I draw the parallel. And I'm going to refer to just my experience. Perhaps some of it would be useful because we learn from each other. And I must say I learned this from my seniors, that this wonderful profession offers you an opportunity of learning at every point. When you are preparing, drafting, preparing to argue, when you're being briefed, when you're standing in a corridor and speaking with colleagues and hearing their experience, when you're in court and listening to others argue, looking at the questions that are coming, when the judgments come, they are pronounced. At every level, you can learn. And it's, I think, therefore, the closest to what life is meant to be, a learning experience. So I often say that as a lawyer and as a practicing advocate who's arguing in court, my role is like a surgeon. And I don't want to come out feeling I should not have done that or I should have done that. Because at the level of at least the Supreme Court, you don't have a second chance. After this, you can only argue with God. That's your last chance. It's the final court. And therefore, it's very important to be that focused when you are doing it. Now, ethics, in a sense, would be the spine or the backbone of the profession. That's how, what I've gathered, reading different places, preparing for today, is that it would be the spine. It's a moral compass that preserves the faith in the system. Now, we are stakeholders. If the system itself suffers any hurt or damage, we have damaged ourselves. You can't, as we say in English, cut the nose and spite the face. It's ultimately the same profession. So we all ultimately are going to benefit or lose with the credibility that the system has and within which what we contribute. So while ethics or integrity is an individual effort, it is a collective responsibility. There's no question about it. And I'm going to just say that the dilution of it in any way is going to be the loss of our profession for ourselves. So we have a stake in doing what our little bit is there. And it's not about what we should do. So for me, at least, it is go back to the basics. When in doubt, go back to the basics, go back to what we are supposed to do, and everything gets okay. And therefore, what is that balance that we have to go or look at? And these are the questions that I'll urge at least the younger colleagues to bear in mind, or those who will join the profession in the years to come, is that we have to draw a balance between the following 4 or 5 things. One is, what are you, an officer of the court or a representative of the client? They are both important, and you have to balance this. Ultimately, you're an officer of the court. You may be called upon on a day, and often we are. I think everyone's been through that. Tell me, Mr. X, Mr. Kohli, Mr. Power, anybody else, what is it? At that point, you have to make that choice. Are you an officer of the court, or is your brief going to dominate that? And you have to do it in an honest way without being disrespectful to the brief, because you are engaged. So it's that balance. That's the first one. The second one is, what are you there for? Assisting the court, or are you there to win the case? Again, it's a balance between both. And these are fundamentals. You have to keep the best interest of the client there, but you can't forget you're assisting the court, because that determines how you brief the court. In fact, Justice Midda of Delhi High Court, when he was retiring, his quote has gone viral. And it's really a quote that sums it up. In any case or argument, both sides know the truth. It's only the judge who's on trial. And in fairness, we have to assist that court. It's not easy. I mean, I have to say that we thank people who decide to go onto the bench. It's not an easy job. It's really not. Because we do 1, 2, 5. On a good day, maybe 8, 10. They do 40, 60, 80 every day. And we ask any judge, their sleep hours are limited. When they travel, it means they sleep less. eventually you have to read part of the brief to know what is happening. So our duty to assist is very high. Not winning at any cost. We assist, put up a best case, and we have to hope for the best thereafter. Knowing when to stop and when to persist. That's another balance that we have to choose. Because often we know that if we persist with this, we may help persuade, because advocacy is about persuasion. We may persuade the bench to accept our point of view. But you also have to know where to stop. And I think Justice Mehta at least has been part of the recent judgment and order with Justice Vikram Nath sir, where I think the advocate crossed the line and he has been imposed with a fine. You have to know where to stop. There is a point when finally the court says, yes, we've heard you, we've understood, this is it, this is our view, we need to draw the line here. So I think, again, that's another point. The challenge I've already covered partly in this. The challenge is to respect time. We all love to hear our voices. We all prepare. We prepare several hours, so we want to bring all the points. But you have to finally bring it down to an essence. The Supreme Court is like a T20 match. First ball, bowled, or a six. You have to manage that in 30 seconds to 2 minutes. The High Court for me is a one-day match. You have a 50-over match. You can play your innings. And the trial court, which is actually the most important, is the test cricket. You have to play for that entire process. I often tell my friends and clients who come that I find it strange, and this is an irony of our society perhaps, that they will invest the least in the trial court, begin to invest in the High Court, and in panic invest everything in the Supreme Court. The same is also in our educational system, ironically. Our nursery teachers are paid the lowest, where the value addition is probably the most important. That's the future of a human being and a universe. And we pay the highest as we go up, where the value addition becomes limited after a point. Your effort really takes over. Anyway, these are larger questions, larger debates. Then now a new challenge that we are facing is the nature of the client and advocate relationship. We've had one case which has been majorly discussed, where the advocate crossed the line and it became a personal relationship with the client, the advocate and the client, which is not correct. It's like a doctor-patient relationship. You have to respect it. Beyond the case, after that it ends, it's something else. But yes, we have to understand that, and therefore I take at least a learning from the medical profession. Often doctors will not like to operate upon their own family members or close friends. And I think some of us, at least in the profession, always mark, this is the person I'll go to if I needed an advocate, rather than, look at it within the family. And finally, I want to touch upon what today is going to be the elephant in the room and something we can't escape, is artificial intelligence. That is going to challenge every ethical boundary that we know. Everything in our profession. There's a separate session on it. I'm sure that'll be equally, maybe even more enlightening. But artificial intelligence is going to be the big issue in terms of everything on not just a profession, but on what is happening on planet Earth, our life. Is that the irony for me is we are now today risking discarding human effort and actual intelligence. We are discarding it. Human effort and actual intelligence, and making a tool which is meant to be a tool for assistance our master. We need to worry about that. In the process, there are 4 or 5 things happening which to me today is the most ethical challenges that we will face beyond ourselves individually. The first is the risk to confidentiality. Look on a paper. When a client meets us, we used to do it. A single computer, something, you've stored somebody's life story. Some of it may be very, very personal. And in personal battles, they are. Now you're putting everything into a learning machine, which is going to learn about it. Now, if I start speaking on artificial intelligence and the horrific things that are happening with, several people are now actually taking counseling advice from artificial intelligence. And at least in one case, it's reported it's a learning machine. And the person, this was a young person speaking, the advice it got is that you are so in such a hopeless case, suicide is your best option. Now, this is serious. I mean, that's what a tool can do. That tool is only just basically picking up and developing its own. There's, of course, another thing which is happening is now you have a challenge, what we used to see in Matrix and other things 20 years ago, if anyone have seen these films, is that the sentient is getting created in artificial intelligence. A sentient, essentially, is a self-learning program which now has emotions, which is able to now actually feel. And there's another reported case that has come out of China. Lordship, it's amazing. That actually a robo, which is basically artificial driven, found out that its workload was more compared to another set of robots. It almost sounds like a trade union exercise. And it shut down. So it's, that's the level to which, and one last thing before I come back to what I was saying, and I'm digressing a bit. Your chat GPT, again, this is something I recently read. The new version is at IQ 155. 160 is Einstein. This is at 155, and it is believed that the next version within a year will be 10x, which means IQ of 1550. So which is why I come back to the first point I made, that we are risking with the tools to risking making a tool of assistance our master at the cost of our effort and at the cost of our intelligence. Everybody is intelligent. They have a basic level of intelligence. No one can join this profession without having that basic level of intelligence. The second is so I spoke about the risk of confidentiality, then inaccurate legal reasoning and case law citation. We have enough now cases. In fact, Chief Justice Suryakant has formed a committee, I think under Justice Narasimha, and all judges are talking about it. You are getting citations and data, inaccurate data, which is completely nothing to do with the real. Now I'm asking a question to myself. The bench is doing that homework. What about us? We are also just consuming what is coming to us. Now I'm just asking myself that do we need to go back to the old school, which means actually start disregarding and accepting anything that comes on our table without checking on it. I mean, and anyone who's in the profession for a long time knows we depend blindly on our colleagues after a point. Because there's a certain trust you have developed, you believe that this is what's going to come to you, it's based on effort. The tools are now running a risk. So there's bias embedded data, there's a confidentiality risk, there's inaccurate legal reasoning, and there's manufactured pleadings. There's manufactured pleadings, there's manufactured case law. And several, recently ITAT withdrew a judgment. There is a certain high court that pulled up a trial court judge to say that he had used an AI tool to actually put a judgment. You've had costs being imposed now by some high courts, but it starts with us. It's happening in our offices, or it's happening in the offices that we know. And I think we owe it to our profession to be careful about it. There's one, of course, as I'm going to be ending in a few minutes, there's one positive thing on AI, but I'll end on that, is that human oversight is becoming mandatory, and that's going to be part of our ethical practice going ahead. You have to have an oversight over what is coming before you. The ethical question that we have to accept is not whether we use artificial intelligence, but how responsibly we do so. You can't escape it. You will have to accept it. But how responsibly we use it is the ethical question. And on the larger subject of ethics, on my concluding is that ultimately we have to find our own balance and our own light. It's an internal process. It's not something that I can ask you, emulate this or that. You have to believe in it yourself. You have to do it yourself. So which is what the Buddha says, Atma Deepo Bhava. Be your own light. And if you build that moral compass around it, you'll do it. So on the lighter note of what is the good thing of AI, that I am at least hoping to celebrate in maybe a decade from now. I'm quite old school and old fashioned, I must admit that. is that we will stop believing what comes before us. We won't have a choice when we see a video. Is this really the person, or this is an image of the person? Is this really the voice? We have enough cases of the voice now speaking like the daughter in panic and the parents transferring money. I mean, this digital arrest is another story by itself. But imagine digital arrest with AI. Let's imagine AI creating the BBC or NDTV or Doordarshan. You won't believe that this is not BBC or not Doordarshan. It can. That's the power of it. So you won't believe it. So I'm looking forward to the day when we will say, let's meet in person. मुझे आप ब्रीफ करने आ जाइए, सामने बैठ जाइए. तो इसका मतलब आप जो मुझे बता रहे हैं, आप ही बता रहे हैं, कोई और नहीं बता रहा. It's there. So on that unhappily happy note, I'll thank you for your time, and I hope something, if I spoke, was made sense. I hope it leaves you with a thought to reflect on, because ethical behavior cannot start with your own introspection and reflection. It's not something we can learn in a book, and thankfully, that's not how it is meant to be. Thank you very much.
Thank you so much, sir. It was indeed a pleasure to hear your thoughts on the topic. And after the box of Kantika from Justice Mehta yesterday and Kantika from you today, I think the sundowner tomorrow is what's going to cure my voice from Patwalia, sir. May I now call upon Mr. Paramjeet Singh Patwalia, senior advocate, whose career exemplifies discipline, restraint, and ethical rigor that have traditionally defined the highest standards of the bar. Sir.
Honorable Justice Sandeep Mehta ji, Judge, Supreme Court of India, Nalin, my friend and colleagues, students, members of the audience. We are today here to talk about ethics in a transforming legal profession. Ethical behavior is something which we have to practice in all spheres of our life, in our relationships to succeed. And therefore, ethics and ethical behavior is something which is very crucial when we practice this profession of law as well. Nalinji said that this is a noble profession which was distinguished from an occupation or a business which is not just about profit. Its purpose was to serve society by creating a fair system of justice. So when I sat down to prepare, I thought, what is ethical behavior? When we started the profession, people had more time. People used to guide more people, and generally the pace of life was a little slower. Now the pace has stepped up. The young student who joins gets sucked into that pace. So sometimes this real crucial 4 or 5 points which go into making a really successful and respected professional are overlooked or forgotten. And they are very simple 4 things, which I was taught by my father by his example. He never told me, but he lived that example from which I learned. First is integrity, honesty. Second, I will dwell upon them a little later, is hard work, competence towards your clients and the institution and the court. Third is your behavior in the court and towards the court, because you are first an officer of the court and then a lawyer for your client. And last, your professional behavior and how you deal with your clients, colleagues, and people around you. When today materialistic pressures have increased, so integrity, to lose honesty, to resist and go through a longer gestation and go for short-term gains is something which attracts and people succumb to it also. But ultimately, if your conduct is such and you maintain and sustain this principle in your life, it will be an asset for you for the rest of your life and your career. An image will be created, and that image will ultimately work to your benefit throughout your career. This is what I have seen over the last 4 decades that I have been in the profession. We have lawyers whom we respect for these things. So therefore, that is the first part of ethics. Second is hard work, competence. Ultimately, you have to perform for your clients. This golfer, Gary Player, said that the harder I work, the luckier I get. So ultimately, you say that man is very lucky, look how well he's doing. But you don't realize that a large part of that luck is actually the hard work which he has been putting in. When I was about to join the profession, my father was the top lawyer in Chandigarh. I thought I will have an easy time, I'll join his office and practice. But the day I joined, 2 months before that, he was appointed as Additional Solicitor General and moved to Delhi. Most of the work which was there, people opposing were top lawyers of the court. I was trying to maintain, sustain as much as I could. And it used to be very worrying, it used to be very scary. I was a young lawyer. And I once asked him that, look, these people have so much experience. How am I going to match up to them? He told me that what you lack in years, you have to make up in hours. So what you lack in years, he said, of experience, you can only make up in hours of hard work. And that is something which I have kept very close to myself. And ultimately, if you have a full grip on the facts, your confidence in court is much more. You can take whatever questions are shot at you. If you have full grip and if you have knowledge in law, then that is also equally important and gives you that much more courage and confidence. So these are the ethical practices which were inculcated and should be inculcated. Next, what I was thinking was your behavior and your duty towards the court. I think it was one of an old-time practitioners in Punjab who told me that, look, when you are joining, you must work hard to ensure that you don't lose the case. But even if you lose a case, always try that you don't lose the client. But he said, even if you have to lose the case and the client, you must make sure you never lose the court. Because the day you lose the court, that is the day when your practice cannot grow. So the first duty of every counsel is towards the court. And then comes your professionalism in the way how you operate. Financial gains is not the only thing. Ensuring access to justice to the underprivileged, to people who cannot access it, contribution to pro bono cases. So the sum total of all this is what ultimately culminates into the ethics of each individual who is practicing as a lawyer. And that ultimately, in the long run, makes or breaks your practice and profession. I thought I should, having got this opportunity, underline these 3-4 things here. Because many times in this space, they get left behind. And people don't think so much about them. In a contemporary world now, as Nalinji said, the challenge is to tackle and meet with advanced digital technology and client confidentiality. Now, sometimes when we are doing matters, and I do a fair amount of service matters where large number of people are concerned, so the lawyer says, can we have a Zoom meeting? Now, when you have a Zoom meeting, you suddenly join and you realize there are about 400-500 people linked. This ease of communication through electronic means, has brought about concerns of data privacy, client confidentiality, information security. So this is the new changing times when we will have to adapt to this advanced technology, and to ensure that all this, it is said that communication between a lawyer and a client is a privileged communication. So to sustain and maintain those old and established conventions is one challenge. And the other, and the more obvious and more looming challenge, is what Nalin talked about, and that is artificial intelligence. And I will give you an example of that just now. When I got the topic for this discussion, I shared it with my son who is practicing in Chandigarh. And within 10 minutes he came out with a speech. And not one, he gave me 3 options. So I said, how have you done this? Where have you got it? And he says, oh, I have a very advanced membership of AI, for which I pay a very heavy premium. Nobody else has that. And that really is the real risk. Because justice has to be delivered, justice has to be secured with a human touch, a humane approach. It cannot be mechanical. So many times we get briefs to be settled, and I wonder that such fantastic English, and you know the person who has written it, and you feel, no, this can't be. So therefore you have to be very, very careful about those and citations which don't exist are appearing. So today the true value of a legal professional will have to be to navigate this mechanism or this artificial intelligence which cannot bear the burden of human accountability. So ethics today will have to meet with this artificial intelligence, and there will have to be a level of responsibility for the people who present the pleadings, people who appear. A third thing in this new evolving practice is your integrity towards the bench. Because media trials are now becoming the order of the day. matters are being discussed, opinions are being formulated, pros and cons, the fairness or unfairness of what is happening in a court is being discussed. Here there is a very simple principle of ethics which I had learnt from one of the senior counsels in Chandigarh. When he was asked to give a bite by a newspaper for a matter which was pending in court, he said to that man that, look here, a good lawyer must do his talking inside the courtroom and not outside. But somewhere along the line, in this whole world of social media where popularities are surging, we have forgotten this very basic principle of a lawyer. So one of the important responsibilities of all of us today is to ensure absolute candor and dignity of the court and to resist from these media and trials which are taking place all around us. So how is the reform going to happen, or how is this change, or how is this going to happen? I had thought that first it must begin with an enhanced emphasis on ethics and ethical behavior in legal education, which is happening, but it is not so much happening today. In fact, in this whole world of commercialization, in this whole world where litigation has enhanced, has increased, today every court in the country, and Supreme Court will have 60 matters, 65, other courts in the country will have even sometimes 100. I remember in 1987, when I was to join the profession, my father told me, you go and sit in the court of two judges who were very vocal and very good, Justice S.P. Goyal and I.S. Tivana. So I went and sat in their court, and they came out and they seemed to be visibly upset about something. They said, call the registrar. So I can never forget this. I was very young. I had not even got a license, I think. And the registrar came. They said, have you seen our list? We have 16 fresh matters and 24 after notice. You think we are donkeys that we will work like this? So that was the workload in those days, and you just compare the kind of workload which today's judiciary is bearing, and one should commend the effort and the hard work that goes into actually dealing with all that, because ultimately at the highest level there is tremendous responsibility in the person who is sitting to take that decision, because you know that you are the last word. So therefore the profession, so first the reform should begin with legal education. Technology must be regulated by ethical standards. We have to come out as from amongst our professional bodies to lay down ethical standards for technology. And coupled with that is, our disciplinary institutions must command credibility. They must ensure speed, transparency, and consistency. And lastly, we must also redefine what success means. Is it merely quantum and what you earn out of it? Or is it that you should value integrity, public service? So, success also needs to be redefined. So, I conclude by saying that legal ethics is actually the backbone and the spine of the profession. But it is something which all of us in the fast pace of life sometimes tend to forget. And it is all the more important and relevant in these changing times of enhanced social media, open communications, and public media trials which we are seeing around us. Thank you.
Thank you so much, sir. So indeed, it is the ethical conduct is what separates principled advocacy from opportunism, persuasion from manipulation, and professional freedom from professional excess. Before I call on our last speaker for the session, I would like to inform all of you that the speakers wanted this to be an interactive session. So we will be taking up questions after Justice Mehta finishes up. So please keep them ready. Sir, may I now invite you on the stage.
Good evening, Mr. Patwalia, Mr. Kohli, Mr. Pawa. Before I start, a big round of applause to the SCBA, SCORA for a fabulous conference. The degree of success of this conference is visible in the attendance in the sessions. Inaugurals, yes, we know that they are mostly well attended, but to have a full packed house in a session, working session, is really important. So I must congratulate Vipinji, Nikhilji, and the entire team, not only to have very well organized conference, but to have included students to be a part of the law students to be a part of the discussions. They are the future of the profession, the budding lawyers. And if they start learning right from the beginning when they are in the college, I think that will make a lasting impression on their future careers. So very interesting topic which has been given for this session, and I am given a daunting task after such eloquent speech of Mr. Kohli and such vast experience shared by Patwalia Sahab, to speak to you on this rather sensitive topic, I must say. Much has been said regarding the noble profession, the responsibility of the lawyers towards the court, the lawyers being the true torchbearers of the profession. I will begin with the teachings which I received the day I entered the corridors of the court. The first day, in Rajasthan High Court, we had a very typical setting that the entrance was a hall which we call the Jubilee Hall, where all the seniors used to sit. So whenever a junior used to enter the court, there was a degree of affection and the sense to guide this young members of bar, that the seniors would call the juniors to them and then give them advice on how you have to behave as a lawyer. So one of the greatest advices which a young lawyer can have was given to me by none other than father of Justice Dalveer Bhandari, Shri M.C. Bhandari, senior advocate. His expression I like to share with you. A successful lawyer is the one who has a large number of briefs. But a great lawyer is the one who has the power to refuse a brief. And friends, I tried to carry that advice in the back of my mind throughout my tenure as a lawyer of almost 25 years. In my experience, I'll share with you that I had a refusal rate of almost 30% briefs on my table. If I was not satisfied, either on the facts of the case or because my sentiments did not allow me to accept the brief, and I refused accepting the brief, invariably the client who had come down to get his matter filed in the High Court or whichever court it was, because I was also practicing continuously on the trial court side, he would definitely approach someone else, some other professional, and the professional mostly would accept the brief. But with experience, you learn that there is nothing in the brief and it is bound to be a negative result. And those very people whom I had refused on my table would come back to me saying, "Sir, you gave us the right advice. Invariably, we filed the brief and what you said turned out to be the truth. We lost." But that little advice, that sacrifice, you may say, that gave me perhaps long-lasting relations. Those litigants whom I had refused from my table, they came back to me, not only with their subsequent matters, but they referred other briefs to me. This is a solemn advice I'll extend to my young lawyer friends, that unless you have the confidence in the brief, be brave enough, be powerful enough to refuse it, because it is my opinion. Of course, there may be different thoughts on that, it's your moral obligation that you can't refuse a brief. But I have had a view that the lawyer must have the courage to refuse the brief. The further fallout of that practice in the later part of my years as an advocate was that the lawyers from the district court used to call me. They used to share the facts of the case with me, and you would ask me, "Sir, are you ready to accept this brief in the High Court?" And if I said no, 80% of them would not even file the application in the trial courts. So that truthful advice to the client is the first learning of ethics which every lawyer must inculcate right at the beginning of the career. The second learning which I got from my maternal grandfather, who was a doyen of the bar in the state of Rajasthan, not by words, but by his deeds, by his conduct. I used to see that if a very affluent client came to engage him in a particular brief, he would often keep the client waiting for long times. No pleasantries were exchanged and were offered. But if a poor man came, he had set up a guest house kind of thing. He would be offered a room in the guest house. He would be offered food. And many a times, I saw the pittance of fees being offered, being refused, and not only that, the return fare was also paid by my grandfather. Those clients, my friends, I'm afraid the lawyers practicing Delhi perhaps may not have that experience, because when you get the one-to-one contact with the lawyers in the district court, the clients in the district courts, it is an experience, an humbling experience, I'll tell you, which perhaps opens the eyes of a lawyer more than anything else can, any other learning can. Those clients, the blessings which those clients gave, perhaps are the greatest earning which a lawyer can have. So that empathy towards a client should be one of the virtues which every lawyer must carry with him. Now we had, in this regard, I'll quote from Justice Krishna Iyer's words. Law is not a trade, not briefs, not mercantise, and so the heaven of commercial competition should not vulgarize the legal profession. So these two learnings, the power to refuse a brief and to treat the client with empathy, and the poorest of them is one thing which, when you look back in retrospect after years of practice and after you have gained significant heights, you will remember that those are the things which perhaps contributed the most to your rise in the legal profession. One more word of advice to the young lawyers and the students who are sitting here. A part of your practice when you start your careers must be dedicated to trial courts. It has been my good fortune, I'll tell you, that we were practicing at Jodhpur in a campus which housed both the High Court and the district courts. And for all my 25 and a half years practice as a lawyer, I continuously practiced on the trial courts. And the sense of satisfaction which we got was unparalleled when we were working in the trial courts. You get close contact with the true suffering of a human being when you practice on the trial courts. One of the most painful experiences I had as a trial court lawyer, I'll share with you, and it brings tears in my eyes when I remember that. There was a matter pertaining to dowry death. The mother-in-law was a disabled woman. The trial concluded, and to my mind, I had a very good case. But the trial judge had his own opinions. The mother-in-law was disabled. She was also convicted. And before me, she was carried away to the jail on a chair. That shook my conscience. The next morning, I rushed to the High Court. I didn't even have the judgment of the trial court with me, and made a mention. I requested the judge, sir, I don't have the judgment, but I want to file an appeal and get it listed today. The next part of my experience, I'll tell you why I succeeded in that. I got the permission, and without there being the judgment annexed to the appeal was listed on the same day in the defective side. An order of sentence suspension was given by the end of the day, and the lady was out on the very next day. That gave me such satisfaction, which is uncompared. Now, why could I get the matter listed on the same day? That is perhaps one of the most important parts of ethics stated in the court, is the truth from the facts. That is what makes a lawyer great, and a lawyer who is truly an officer of the court. Coming back to that experience, one of the matters I had filed, and I stood up and started arguing. The honorable judge straight up said, what kind of brief you have brought in the court? Because it was a case wherein a young girl had been molested. So the honorable judge knew that I would never accept such briefs, at least not from the side of the accused. I immediately apologized and said, sir, I am withdrawing from the brief. So that kind of presence, if a lawyer can make in the court, that is the true proof or the true evidence of the integrity of the lawyer, the qualities of the lawyer, and of course, evidence of the fact that the lawyer is acting true to the profession. I have a prepared speech, but since everything was coming out from experiences. So I thought that it is that I should also share my experiences, having worked on the trial court side for almost 25 years and having had a first-hand experience of what a poor client expects when coming to the courts. That very experience and that very kind of empathy which I learned from my seniors really proved to be wonderful in life. I had clients whose appeals had been decided in the High Court, they had been acquitted, approaching me after 2 years, said, this was your fees which is outstanding, we want to pay it. So if you have that empathy, if you have that connection with the clients, I'm sure the degree of satisfaction which you get, even by winning the brief of a billionaire, the degree of satisfaction which you get by getting relief to that poor man, the last man standing, as they say, is unbeatable. I once again thank the SCORA and all the learned advocates who are here for having given me this opportunity to share a few of my experiences. Thank you. Jai Hind. And now, of course, as Asta has said, we'll take questions.
Can I please pass on the mic for questions?
One thing, a rich man will give you a fee. A poor man will give you blessings, which are much more than the fee.
Anyone from the audience, please?
Sir, do you feel that doing a rich man's case is actually easier because they have their papers and orders, they come with their every bundle ready, and they come with notes, while a poor man will have some Hindi copy, some loose papers, and so even to got the papers.
I'll just respond. A very, very important experience I had in the Supreme Court. No, it's okay. I'll come here. So, a very important fact I just forgot to mention. When we were hearing the experiences of Mr. Kohli and Patwalia Sahab on translations, I'll tell you one serious issue which is presenting in the briefs before the Supreme Court. I was sitting with Justice Gawai, and we had a appeal arising from a conviction. It was a case from Delhi. The man was absconded years, the accused, and in his abscondence, evidence had been recorded under 299 CRPC in absentia. The argument which was raised was that, look here, sir, as a matter of fact, the evidence was never recorded on oath. The witness did not appear in the court, and only his previous statement under 161 CRPC was exhibited by the officer. When we saw the translations, it seemed so. But as I shared with you, I have been a trial court lawyer all my life. I was not satisfied. I felt that the trial court could not have made such a blunder. I called for the original file. And when I saw the original file, I was shocked. Rather, I was sure that this is bound to be the situation. Proper proceedings under 299 had been drawn up. The witness was in the court. His statement was recorded on oath. So that is the blunder which we are committing many a times by blindly accepting the translations which are presented. And of course, the AI translations are something which we are all experiencing nowadays. So my friends, please don't believe on these translations. Wherever you have the opportunity, you have seen us working in the courts. Wherever we get the opportunity, whenever we know the language, because records are in northern part of the country, most of the records are in Hindi. We are more than happy to read the original records without there being any translation. And it makes a huge difference when you see the original statement on record. So my advice that don't please believe blindly on the translations. Try to look at the original record. It gives an entirely different perspective. Thank you. And to respond to the question of learned counsel, see, whenever there is a rich man's brief, always be suspicious of the facts which are presented. A poor man will always speak the truth.
Actually, it's to say that it's more difficult to do a rich man's case or a poor man's case. It's cases are a poor man can have a complicated issue also, land here, there. Rich man will be better assisted in that sense. Though I wonder which bundles you were talking about. So,
Your Lordship had shared his experience as a practicing lawyer when you would refuse cases your Lordship would not believe in. But there's at times as a young lawyer one faces a dilemma, one doesn't have the means to actually refuse cases left, right and center. And secondly, one also feels that the person, whoever that may be, also deserves a fair chance at being represented, whatever the case may be, good, bad, ugly. And so am I getting into the shoes of a judge, which is not really my job, and as opposed to being a lawyer and doing best for whatever the eventual decision might be? That's a dilemma one has to face every day. What would you like to say?
The experience which I shared, the difference between success and greatness, that is what the difference is. And yes, so far as that young struggling lawyer part, I'll tell you, if that perspective has to be there in every lawyer, that first 5 years are bound to be a struggle. That is a part of the profession which one should never forget, come what may. And being a judge, yes, that's a perspective, that you are assessing the brief. You know very well that is bound to fail, and still you charge money from the client. I'll tell you, I never accepted MACT briefs in my office. I felt that I can't accept money which is coming from a dead man's suffering. That was my perspective. I never accepted. I passed it on to someone else. That was my moral perspective.
Sir, I have a question. So we all know that it is basically the trial courts where we need the best legal assistance, right? But do you think that Supreme Court practice is becoming more glamorous, especially with proceedings going live on YouTube channels, the Constitution Bench hearings going live, and now we also see some of the proceedings getting recorded and being telecast on different multiple YouTube platforms? What is your take on that?
So far as the proceedings becoming glamorous, I don't know, with the presence of such glamorously dressed lawyers, it may be true. But for me, the glamour was always in the trial courts, where you saw true emotions, the basic facts coming to fore, the procedure being followed. Unfortunately and very sadly for me, in Supreme Court many a times the procedure is totally sidelined. As of course they say that procedure is a handmaid of justice, but for me, procedure is always sacrosanct. And if you sacrifice procedure, it may be glamour, but for me it is far from truth.
no, but here I will tend to disagree with you, because see, you are talking of those 1, 2, 3 cases which are picked up by the media. Supreme Court on a day-to-day basis is not those 1, 2, 3 cases. We have 16 courts doing 70, 80 cases a day, and most of them are all bread and butter litigation for where the client's life is at stake. And if you actually see on a personal perspective for that single individual who has that one case, I mean, what is going on in any other court in a normal matter is as important for that individual. And so therefore, it's not glamorous. We've always had the glamorous side of the Supreme Court, right from day one. Then we heard less of it. Today, because social media has so opened up, and as you are saying now, I also at night sometimes start picking up clips, and these algorithm will then bring it again back. So if you see 2, 3, then you have gone. Then you will only get. So yeah, yes. So I mean, this all goes hand in hand. But really, what all of us are doing is actually very bread and butter kind of work, actually,
Absolutely.
I want to go back to the previous question. I'll avoid the glamour one, otherwise it'll be said vested interest. But I want to go back to the previous one. It's a fair question. And we all draw our lines. I think what Justice Mehta sir was saying is you draw your lines. For example, in my lines, what I would see in a file to be a genuine rape case, I just won't do it. It's a red line for me. I'm not going to do it no matter what the money. I'm not going to do brutal murder. But have I done a murder appeal? Yes, because the facts present themselves. Not every murder is premeditated or brutal in that sense. Death happens. So this is it. The second is the moral dilemma. And that also, incidentally, I must say, is a Rajasthan-related story. I was AG, Additional Advocate General of Rajasthan. And this taught me something. And I must say that's my most painful case. I had to carry that burden on my shoulder for a long time. It comes from poverty. We, after a point, become mechanical. Appeal hai, High Court ne kya kiya isme? Are, how could the High Court do this? No, this is the law, this is the thing. So appeal must be filed, and I must point out that if you take your brief seriously, which is what I learned from one of my seniors, if you treat a government case yateem hai, private case ka baap hai. The private case mein us khada hai, which is your point, with every possibility, this is it, know what is your research, how much have you done. But the government case is left to an officer somewhere, he sent you the file, you have to do everything. This was a case of a murder conviction overturned by the High Court after 17 years. And we filed the appeal and obviously got a notice and stay. And then the police went out to catch the accused. And when they bought that accused, that for me was my most painful day. He was a man of abject poverty. No question of him even being able to hire a lawyer. And the reason he was not absconding, he was just a poor man not existing at the place where that address was given. And I felt miserable. And oh God, what have I done? Now came the moral dilemma, which is the point you're raising. That was I not true to my brief? I was. Could I have done otherwise? Because the state expected me to give my reasoned view on an appeal should be filed or not. So that again an elder in the profession told me, Nalin, namak ke saath sacha rehna. If you have taken the case, don't be unfair to it. You must follow it, even if you have then a moral dilemma, or give it up. So I think the second learning in that was, and just to conclude this, is be a little more alert about what you're doing. Don't lose sight, which is what he's pointing out again, Lordship is, that about the trial court. Realize at the end of the day, it's not a story, it's not an appeal, it's not a case, it's not a file. It's a human being. Somewhere or the other, it's them.
Sir, my question is to Mr. Kohli. We heard your thoughts on artificial intelligence. But sir, today the impact of AI on everyday life is undeniable. We also know that it does have its negative impact, it also has its positive impact. So should we only see it as a foe, or should we also see it as a friend and embrace it, because we know that tomorrow it will be the age of AI?
My point was exactly what I'm saying. It is a tool, not your master. Don't be enslaved by it. Rule it. Use it as a tool. And that's my point. The over dependence or the blind dependence is what I'm talking about. You have no choice. I mean, and I'm honestly hoping I will be retired and gone by the time it hits its peak, which I think is going to be sooner than I planned, which is very good actually. And it'll be good to retire and get down to life per se. It's not the files. But use it as a tool. You don't have a choice. So I had a colleague of mine who, Gen Z as they are, depended exclusively on ChatGPT. And one day I knew I had to stop it. I kept advising him. So I found my way of dealing with it, which is when he came and looked very impressed with what he had turned out. I said, wonderful. Put it aside. I gave him a paper and said, now my style. Take my pen. लिखो जो तुमने मुझे दिया है. वो लिख ही नहीं सकता है. उसको पता ही नहीं उसने क्या दिया है. And that was the point I was making. Do you even read what you have got? Now in our practice in my chamber, my colleagues have to check the judgments of a note that has come from an unknown source. Just go to the judgment, seize the judgment and the para mark. An easy way to do it. It's not a complicated. Para का size क्या है भाई? पहले 3 word पढ़ लो, last 3 word पढ़ लो. If it is same paraphrase out of SCC, you know it is picked up from SCC. That's it. So use it as a tool. I'm not denying you the right. I don't use it. I don't want it on my phone. I know my phone must be having plenty of things. So I don't. I'm very clear. You all do it. As far as I can avoid it, I am avoiding it. I'm not downloaded ChatGPT. I'm not seeing the face of it. I have no intentions of seeing the face of it. I said I'm old school.
Good evening, esteemed panel. Please. Good evening, esteemed panel. At the cost of incurring odium of every lawyer present here, but taking courage from Lordship support to the trial courts, while the Honorable Supreme Court has come down persistently and consistently, rather heavily against the culture of strikes or no works, the trend or the prevailing trend in especially the northern part of the country and especially the trial courts is repeated strikes, which not only burdens the courts to meet their targets within a lesser number of days, but also to a very large extent is unfair on the clients or the litigants who step into the court not knowing that nothing is going to happen. So what will the panel's views be to every lawyer, every litigant? And I would pose this question to through this panel to every person who's involved as a stakeholder, so that such things can be avoided in the future.
It's absolutely relevant point you have raised. The strike issue, you see, it is a sensitive issue, no doubt about that. The bar associations have their own reasons why they are indulging, but someone needs to tell them the impact. One strike of 7 days affecting the work of a trial court puts back the clock by no less than 6 to 8 months. You know very well in NIA cases, one date you give either in Delhi or in Rajasthan where the courts are having more than 10,000 cases per magistrate. So one strike, that particular day, the date will be deferred by 1 year, not less. So the litigant, the suffering of the litigant is tremendous. And unfortunate part is, despite Harish Uppal, despite repeated directions, Rajasthan High Court Bar Association at Jaipur, judgments, the strikes persist. And I'm really at a loss to say whether there is a solution. Because that is taking the democratic principles or democratic rights to the extreme.
बताओ. I said, sir, adjournments पे रोक लगानी चाहिए. He looked at me. और कोई सुझाव? So I said, sir, इस वर्ग का टैक्स बढ़ा सकते हैं. बोला बहुत बढ़िया नलिन. And it was a group. बोला बस एक नलिन की कमी थी अगला चुनाव हारने के लिए. So, that's another real part of it. So I think, again, it all comes down to it. I favor the black band approach. I favor that we have a right to protest. You must wear a black band. You should do it. But the black band approach is based on high ethical and morality. That, that feel of the persons who are seeing the black band must feel that they are protesting, and therefore, there is a cause there that we need to address. Regrettably, in the numbers game and in the war of conflicting claims, looking at the space for them to be agitated, which is, a journalist may have a cause, a farmer may have a cause, a lawyer may have a cause. Everyone is fighting for the noise that could be created for the issue to be highlighted. So in a noise culture, and we are in a noisy world now, being bombarded with information on an overdose, the fight is for what would make it to the eye or the ear. In that, these are the tactics that eventually become recognized tactics.
Just to give a very short reply after all the point is that strike has been happening, but over the years now it's greatly reduced, it's greatly come down. Now, as a community, as we are, as lawyers, I don't really, I think we have to, up to a point, a little bit live with it. But I remember also in our court, earlier on any death, after lunch we used to have no work. Now those things are reducing, but this debate is not going to, this debate is not going to finish anytime soon. Yeah.
Adding to what Mr. Kohli said, this question is for Justice Sandeep Mehta. Sir, keeping in mind the human aspect that, especially in the criminal system, one person's justice or idea of justice is someone else's travesty. Is it hard for, as a human person, to decide a particular case, keeping the human, the victim and the accused family, their future in mind? while deciding as to what to do, or do you have to strictly go by the law, or does it have a very heavy bearing on your mind when you have to keep the accused family also in mind while deciding something?
The simple answer is the courts, of course, are required to be empathetic, to bear empathy towards the victim, towards the accused whenever required. But ultimately, it is the evidence which matters. What is presented before the court for evaluation, that is the material on which the case travels. You may have a very gruesome case involving the violation of a young child, including the murder, and ultimately, when you find that the conviction is based on no evidence, what is the ultimate outcome which you expect? And yes, if you want to wish over the fact that yes, no evidence, still we want to morally convict, I think the time is past. Moral convictions, of course, take place, but what kind of disastrous consequences they can have, I'll tell you one experience from Assam, which is again Mr. Nalin Kohli's field. I was hearing a criminal appeal. The man was behind bars for more than 10 years. It was a case wherein a truck driver had been done to death. There was no eyewitness, circumstantial evidence case. The trial court, merely acting on the recovery of one mobile phone, I distinctly recollect the entire evidence which was there in that case, convicted that man. He did not have any legal assistance at all. Ultimately, when the appeal came to the High Court, the previous bench in 2019 passed an order that, all right, call the owner of the transport company who was operating the truck. He also came in evidence. He also did not prove anything. So that was a semblance of evidence which could have been on the record. But when the trial court convicted the man, even that evidence was not there. The man remained in custody, can you believe? And that mobile phone was also not identified with the deceased. It was not connected. Remained in custody for 10 years on that trumped up charge, I would say. Now, whose family you look at? The family of the accused or the victim? Tell us, please. You get the answer? It's a very difficult task to decide the particular case wherein it's a very brutal offense. But ultimately, you have to look at the evidence. The courts just can't ignore the evidence.
Here I would also even pose this to Justice Aparanta. I think the Supreme Court is the one court where the sense of justice can prevail much more than in any other court in the country. Because first, it is the final court and you are supposed to let your sense of justice prevail. And also, if I may say so, you can actually get away with it, may not be the right impression because there is
I'll respond to that once more. No, the problem is that what is highlighted is the few cases wherein even in brutal offences the accused are acquitted. But the number of cases wherein convictions are upheld, They are not never brought to the front. Those statistics nobody has. The number of convictions which have now risen with proper evidence being collected. And in every judgment wherein you would find, in every judgment wherein the court is somehow, I would say, compelled to acquit for lack of evidence, there always is a guidance that how the evidence should be recorded, how the evidence should be collected by the investigating agency. That guidance is there. So for their failure, whether one side should suffer. There have been cases wherein the evidence was lacking and the courts have stepped in by accessing powers under 391 or 311 to get more evidence, or even directions have been given for further investigation. So instances are not few. There are a large number of incidents wherein these directions have also been given. Just the instance I cited you before you, that Assam case. So the High Court directed recording of evidence of that man, but even that did not help the prosecution. What to do then?
Sir, also one thing. It's a very interesting, but just one thing on the quality of evidence. I do a lot of this litigation where young lawyers want to compete and become judges, and they become and they don't succeed, and that goes to courts. My experience over the last 3-4 decades is that the quality of people who are now going and joining the lower judiciary or the original court is really top class.
Yes, no doubt.
You know, it's a very vigorous.
Again speaking from personal experience.
Yes.
I was a part of the interview board for selection to the Judicial Magistrate JMFC, and few of the candidates, after questioning them for 10-12 minutes, we found it very difficult to frame another question to ask the young candidate. It becomes so difficult. And then we realized that yes, the quality is really improving. And those officers, I had the good fortune to interview 2 batches, 2020 and 2022. And both batches, and I'll say with great degree of pride and satisfaction, 70% women in Rajasthan. Success rate, yes, 70%. And most surprising, but yet very satisfying, I went to the J&K for the valedictory session of the JMFC training module, and 50% candidates were women. Yes. So things are looking up. The young officers are very bright, very well informed, and I'm sure the judiciary is going to places, and this dilemma which we face of delayed justice, with times to come and proper infrastructure, of course, we should improve a lot.
There is great focus on infrastructure.
Again, you know, I first of all, now really, I must compliment Scora, as Justice Mehta in the beginning said, because, you know, some very engaging new things have come. 2 quick things. One is, I think every lawyer, in whatever degree of success, does pro bono matters. There's no question about it. And I have something which is coming from another Assam experience. Our suggestion would be, pick up legal aid when you have time. You know, it's the legal aid which is leading to justice. Because these are people who are actually incarcerated mostly in criminal cases, and weakest section 10 years, 12 years. And Supreme Court, which is what Patwalia sir was just pointing out, is where they are getting that acquittal.
I'll tell you, my experience in the High Court was that every month at least there were 6 or 7 letters from the jail requesting that he should be appointed our lawyer as a amicus curiae. And of course, I never submitted a single bill for all those pro bono briefs in which I had been appointed as an amicus curiae. I must have done hundreds, I don't even remember the numbers. So once you have decided to support this cause, there is no question of charging anything, irrespective, it be from the court, it be from the legal service authority. That's one of the greatest opportunities you get of having a brief with you. The young lawyers should look forward to that. And once you get the chance, you should be more sincere to that brief even than a paid brief. That's what the obligation is.
Those actually, they are. If you do it pro bono, it's not a brief which gets you nothing. As I said, they go and spread your name their word of mouth, they talk about you, they praise you, and you know that percolates in the field from where you get, and that's how it comes back to you.
Yes. Good evening, sir. This is a question for Honorable Justice Sandeep Mehta. It is not from a law students, it is from the client side. Yes, it is very painful for any client to knock the door of Supreme Court, because whenever he asks for justice, goes to the department, or when he approaches to the tribunal or high court, lot of harassment are done by having hand in gloves with the government. Criminal cases are filed against them, disciplinary proceedings are taken against them, they are suspended, major penalties are imposed. By filing 10 petitions in High Court, they are resuming their services. And when matter goes to the Supreme Court in lamine petitions are dismissed. It's very painful. Supreme Court should understand the matter, should look into it and dispose it, because out of 100% people, hardly 50% will manage to knock the door of High Court, and hardly 10% will knock the door of Supreme Court. And how much painful. Please pass this message to remaining judges in the Supreme Court.
I'm actually not being able to follow your question completely. Your problem is with whom? The Supreme Court or the lawyers in the Supreme Court, or
No.
or
Yes, when the matter was disposed of, sir.
who's the problem
Yes.
there?
When the matter was disposed of in lamine, requested the lawyer to file a review. He said no use, it will heard in the cabin of the judges. Thereafter you have to go for curative petition. So this many petitions a poor client cannot withstand with the present system.
It's like this, that you should realize, for a very short time, I have also been a judge, very short time. You should realize that when an individual sits on that chair, whether that chair is in a trial court, in the High Court, or in the Supreme Court, there is only one sense in his mind, and that is the sense of justice. It is very difficult to do anything else sitting there. It is very easy to be critical of what is done. But you must realize that it is very difficult to do anything else but the right thing. Every human being has his own sense of right and wrong. So therefore, once we have put somebody in the position of a Supreme Court judge, we must trust, and all of the people who are manning that have years of experience behind them. So therefore, dismissal rates are high, because our Supreme Court is, the Supreme Court of United States does how many cases in a year? Which is a small fraction of what we do in a day. So therefore, the dismissal rate has to be high, and
There is spite thereof. The judges are every day indulging in grilling, file reading, passing the orders. Most of them don't reach home before 8:30, 9 in the evening. The staff, the High Court staff, if you go and see, they have aged twice what they actually are. So your perception that it is injustice is perhaps uncalled for. When the matter reaches the Supreme Court, it has passed through almost 3 or 4 filters. So beyond that, there is a limit. Every man, parties who come to the court, ultimately there is one winner and a loser unless you go for a mediation. So that is perhaps your solution. Thank you.
Thank
I
you.
have a stake also to answer that. And in fairness, मैं थोड़ा हंसते हुए भी कह देता हूँ, I have not met a person who's drunk and you ask him तुमने पी रखी है, वो कहता है नहीं. So we are entitled to believe in our right, which is correct. My case is the most precious to me because it's my case, and certainly that sense would be that I have been wronged, even if I was not able to appreciate the legal point. But bear in mind, in every case, the unfortunate judge is going to be abused by one side. Because koi to jeetega, koi to harega na. There is always a winning and a losing side. And that's not an easy job. Third, I want to say that the experience after a point is so much that it is like doctor na Ayurveda mein nabs pakad ke bimari bata dete hain. That you have reached that level of experience where you're able to catch the core point. And I said earlier that it's about law. You have to have a case on law, not emotion. Justice is different. I mean, but again, evidence pe hum murder pe hi baat kare. We'll have to appreciate that. I know of at least of multiple people who have gone to the bench. They get up at either 4 or 3:30 or 3, and the record that I have heard now is 2:30. There is at least one judge who gets up at 2:30 every morning, just to have the basic facts. And we do 5, 8 on a very good day, 10 matters, and we say bahut ho gaya. It's not easy. So you have to respect the process after that.
Well, thank you so much. I think that's all the questions that we can today. And I just want to inform all of you that the recorded session of this session will be available on the Skoda website for all of you. And that after this, please join us for a poetry session by Mr. Kapil Sibal in the Grand Ballroom, which is a specially curated session for all of you. May I, before closing this session, request Mr. Karthik Pant, Advocate, to kindly present a memento to Honorable Justice Sandeep Mehta. May I request Mr. Subhanshu Gupta, Advocate on Record, to kindly present a memento to Mr. Paramjeet Singh Patwalia, Senior Advocate. May I now request Mr. Anand Singh, Advocate, to kindly present a memento to Mr. Nalan Kohli, Senior Advocate. Thank you so much to all our speakers. It was an engaging session, and I think because I couldn't speak, everybody else to go over for me. So thank you so much for that.
Give us the opportunity.
Yes, to speak. Thank you.